3 seconds, 2 seconds, start. The appellant was charged under sections 302 and 326 IPC for having caused the death of 4 persons of a family. He was also charged with having caused injuries with the sharp-edged weapon to the mother of the deceased, one and neighbor of the deceased. On proof of charges, the trial court convicted the appellant of the offences punishable under sections 302, 326, 325 and 323 IPC. As he was sentenced to death under section 302 IPC, the trial court did not feel the necessity of awarding separate punishments for offences under sections 326, 325 and 323 IPC. The trial court submitted the entire proceedings to the High Court for confirmation of the sentence. The appellant also filed an appeal against the order of conviction and sentence passed by the trial court. Both the criminal death reference number 1 of 1998 and the criminal appeal number 109 of 1998 were disposed of by the judgment impugned in this appeal by confirming the conviction and sentence awarded by the trial court. Not satisfied with the impugned judgment, the appellant has preferred the present appeal in this court. We have heard the learned amicus curiae appearing for the appellant and the learned counsel for the respondent. We have also perused the record and minutely examined the evidence laid in the case. The report recording the mental state examination of the appellant has also been examined by us. Learned amicus curiae has submitted that as there was no direct evidence available in the case, it would not be safe to convict and sentence the appellant for the offense of murder as has been done by the courts below. We are not satisfied with this submission. It is generally believed and accepted that the witnesses may lie, but the circumstances cannot. The trial court has enumerated the circumstances appearing against the accused as under. The trial court has rightly concluded that the prosecution had fully established the existence of the aforesaid circumstances, and the circumstances narrated created such a complete chain in itself, which lead to the only conclusion that the accused had committed the crime with which he was charged. The High Court also, after examining the statement of the witnesses, the recovery memos and the confessional statement of the accused, came to the conclusion. The entire evidence brought on the record of the case, in our considered view, creates a chain of circumstances with no missing link, which points to the guilt of the accused beyond reasonable doubt. Minor contradictions and inconsistencies here and there in the peculiar facts and circumstances of the present case do not create any doubt about the prosecution case. This court in Malampati Patabi Narendra versus Gathamani Maruthi Prasad 2005 SCC 226 has ruled that In an appeal under Article 136 of the Constitution of India, normally the concurrent findings of facts relating to appreciation of evidence would not be reopened. In the present case, we do not feel and find any good ground to deviate from the general practice. No circumstances has been referred to requiring reappreciation of evidence. We have thus no hesitation in upholding the conviction of the appellant as recorded by the trial court and confirmed by the High Court.